morning.
Good morning. Today is October 30th, 2025, and welcome to the New Possibilities Hour, part of the Will Work for Food project, founded by Natalie Armstrong Motan. Every Thursday morning, Jean Lawler, David Schraga, Michael Schwimmer, and I are delighted to host another cutting-edge webinar for mediators, arbitrators, lawyers, and everybody who negotiates. As you know, there's no charge for these great programs. Rather, we ask you to contribute to a food bank if you like what you see. And it's just great every week when we announce the running total of just how much our generous audiences have contributed since we began the series in 2020. Jean Lawler, would you please do the honors?
Absolutely. Good day, everyone. We are up to $888,127.41 in donations, of which we've been told we're going to cross that $900,000 number really soon and maybe even get to $1 million before year end, which would be fantastic. Thank you all for your generosity.
Thank you, Jean. Today we have another wonderful presentation. We have Jennifer Doan, the president of the American Board of Trial Advocates. The topic is Civility Matters, the importance of civil communication in law and in life. Jennifer Haltom Doan is a founding partner of Haltom and Doan, a boutique trial and appellate firm based in Texarkana, Texas, and Arkansas. With over 30 years of experience, she has represented Fortune 100 companies and individuals in high-stakes complex litigation, including product liability, intellectual property, and many bet-the-company cases. Double board certified in civil trial law and personal injury trial law, Ms. Doan has secured defense verdicts for clients such as Hewlett-Packard, Amazon, and Yahoo. She currently serves as national president of the American Board of Trial Advocates and is a frequent speaker nationwide on litigation and trial practice. Jennifer Doan, we're delighted to have you here. Please tell us a little bit about the food bank to which you'd like people to contribute if they're in a position to do so, and then on with the presentation. The floor is yours.
Thank you so much, Jeff. So today we're raising money for Harvest Regional Food Bank. It's a food bank here in East Texas and in Southwest Arkansas. I used to volunteer there, for at least 15 years. It's a wonderful food bank. And, they announced today, if anybody is watching the news this morning, as of tomorrow with our government shutdown, we're expecting 37 million people will lose their benefits, their SNAP benefits, which we used to know as food stamp benefits or food assistant benefits. So food banks are really stocking up across the United States. Jeff, when you and I talked about this program 6 months ago or so, neither one of us could have expected that we would have had a government shutdown at this time period, or that food banks would be so important now, today, than ever. So we really encourage you. I know we're at 880,000. If we could cross that $900,000 mark today with donations either to the Harvest Regional Food Bank or to the food bank of your choice, that would be wonderful. And you could donate right through the Will Work for Food website. So how you got here. So I think it's really important that we look at this now more than ever. All right, so today we're talking about civility, the importance of civility in law and in life. There's a couple of different things that I want to talk about today, and I know that this is sort of a conversational approach. I am not a lecturer necessarily, especially for the length of this program. So if anybody has any questions at any point, just holler them out in the middle of the program, and that's totally great with me. Or there'll be times I stop throughout the program just to make sure we're all on the same page, if anybody's got any additional comments. Why do we have this government shutdown now? There's a whole bunch of reasons why we do. And so we're not going to make this political at all. So pick your reason. But I think all of us as Americans can recognize the importance of conversation, of communication, and of good civil communication, because we don't have to agree on all the points in life, but it's important that we communicate about them to reach a common result that is good for not only the situation that you may have when you're trying to resolve a case, or a situation you may have as a case progress, but also a situation where whether you're in your government or your marriage or school or whatever. It's really important in today's world that we teach that aspect. That's something that we seem to have lost through social media and through the aspect of, if I could just get the last word in, if I could just let them have it, it seems that we've really lost that in social media. And it's more of a top-down approach as we go through our life and where we see it. And as we all know, that we can get so much more done if we just sit down and say, okay, these are the things we can agree on, these things we can't. Here's the problem that we have. How are we going to work together to creatively solve this problem? So, it's been 250 years since we've had this experiment of this democratic republic that we call America. And it's so important that we move forward in that democratic republic with communication. When our country was founded, the communication was the largest vehicle. We knew it was such a different aspect. We knew that people didn't always agree. If you've watched the musical Hamilton or listened to the music of Hamilton, they really tell you, listen, we don't agree on a whole bunch of things, but we know we have to get a monetary system. We have to get a government system. We have to get some type of banking system. We have to decide where the government's going to be located. Those were all huge issues that, of course, England was banking on the fact that we would not be able to resolve. And yet, because the founders all met together, we were able to resolve basic problems here. So, the American Board of Trial Advocates, I'm very blessed to be president this year. The American Board of Trial Advocates is an organization that teaches civility and it promotes civility. And the American Board of Trial Advocates. So the American Board of Trial Advocates is an invitation-only organization made up of experienced trial lawyers. We have plaintiff and defense trial lawyers. We like to think we're one of the most elite groups in the United States. There's over 7,000 of us. We are all United States trial lawyers. And we believe in promoting the Seventh Amendment right to trial by jury. So we're all civil trial lawyers. Promoting the Seventh Amendment right to trial by jury, defending the independence of the judiciary, upholding the rule of law. And we do all of that through integrity, civility, and professionalism. The fourth aspect is what we're going to talk about today. All the three other tenets are so important. But to be an ABOTA lawyer, the fourth aspect is one of the most important aspects that we have. In fact, that is the aspect that we see in complaints about trial lawyers all over the United States. It's usually not that they didn't know what they were doing. It's usually not that they didn't believe in the amendments to the Constitution. It's usually not something about the judges or what the law was that the judge is applying. It's usually that lawyer was not civil or they weren't professional. So what do we do to address that? Well, this year, ABOTA started a podcast called ABOTA Speaks. And we were lucky enough to have, just a few weeks ago, we were in Austin at our fall national conference with Paul Begala and Karl Rove. And if you are at least my age-ish, I am the latest of the boomers, you will know that Karl Rove obviously worked for the Bush administration and Paul Begala worked for the Clinton administration. And they were both brilliant strategists for those two presidents. It's interesting to learn that when we were getting ready for that program, this was the speaker series that we had the most comments about. And we would have people say, I cannot believe you're having Karl Rove. I cannot believe he's going to come. I don't believe in the things he says. He is way too far right for me, etc. Or I can't believe you're having that flaming liberal, Paul Begala. There's no way I'm going to listen to him. I can't believe you're going to have him on one of our ABOTA programs. Now, when they came in and they talked to us all live, at the end of that segment, we had people stand up to say, I really couldn't stand you. It was either Paul or Carl. But after listening to you today, I love what you had to say. Jill Webb is the host of the podcast On a Boat Speaks on this particular episode. You can find it anywhere from YouTube to your Apple podcast to Spotify, whatever your favorite ones are. But this particular one lasts about 35 minutes. You know, Paul and Carl were vicious enemies when they first met because, of course, they're hired to talk about the other side and how bad the other side's strategic position is. That's what they were hired for. Then they got to know each other, and then they realized how brilliant each other were and the respect that they had for each other. They're not going to agree on all aspects, of course, but they can put a pin in the conversation to agree to disagree, and at the same time talk to the other side with a new appreciation and understanding that I know what they are saying they believe. I know how bright they are. I like to think I'm bright. I like to think that I believe what I'm saying. So let's come together to find a common resolution between the two sides. Their conversation is lively. It talks about America today and what we can expect from America today, the polarizing impact of social media and what we as adults can do with social media and teaching our children to put it down, or our younger people to put it down. It's not all about what somebody in a vacuous setting has to say about you. It's about what you can give to others through your civil discourse. So definitely take a look at this at the podcast. It's a listen. I don't think it's like a webinar recording. It's just a listen. You can do it while you're driving, while you're running, while you're doing nothing and just sitting down. But it can always be in the background. I really encourage you to listen to it. It's one of the best ones we've seen on the conversation on civility. ABOTA also has been instrumental in making sure that our oaths that we take when we become lawyers throughout the United States has a civility component. It's a big drive of ABOTA, and this is our Civility Matters map where it lists all of the states, the dark blue states, which now have that type of oath of civility that every lawyer takes when they're admitted into that state. So for example, in California, where I know you guys are this morning at the offices for Will Work for Food, there's a statement in the California oath that says, I will strive to conduct myself at all times with dignity, courtesy, and integrity. And then over here in the flyover states in Texas, where I am this morning, our statement is slightly different. And it says, and I will conduct myself with integrity and civility in dealing and communicating with the court and all parties. But we've got a printout on our website at www.abota.org of what all the states have. You can see the light blue states that we're still working on to have civility in their oath. And I can tell you that as we work with those various states, and if you are one of the lawyers in those various states, reach out to me. And the website to use, the email to use for today is abota@abota.org. We would love to hear from you, and we would love to be able to work with your state to have the civility component so that every lawyer admitted into your state will make sure that that rings true to them as well. You know, we also have for ABOTA, we have the professionalism code. And why is that important? I think it's important that we recommend and we remember what it was like and the importance of the professionalism code that we took when you're 5 years out, 10 years out, 15 years out, and over 30 years out, to remember what we really want to do as lawyers. So when you're an ABOTA member, the code of professionalism that you adhere to states several things. There's just a few. I think there's like 8 of these. You always remember that the practice of law is the first and foremost a profession. That is something that I think that people try to take away from us now. They want to make us a commodity, a vendor, to be owned by anybody. We went specifically to school, and we are licensed as a profession not to be owned by non-lawyers and not to be a commodity or a vendor to our clients. As a member of ABOTA, we also encourage respect for the law, the courts, and the right to trial by jury. We always remember that my word is my bond, and honor my responsibilities to serve as an officer of the court and the protector of individual rights. In today's world, it is so important to remember that your word is your bond. When I was a younger lawyer in a much larger community, we had to scramble off, and anytime you had a conversation with somebody, you had to write it down verbatim and record it and make sure that everybody agreed to adhere to it. But as an ABOTA lawyer, if you give your word, you want to make sure that you honor that word at all times, whether you're dealing with your client, with the judge, or especially when you're dealing with the other side. We want to contribute the time and resources to public service, public education, and charitable and pro bono activities in my community, such as this program today. I mean, what a better way to talk about civility and the things that ABOTA promotes, while at the same time raising money for food banks across the United States. We want to work with other members of the bar, including judges, opposing counsel, and those whose practices are different than ours, to make our system of justice more accessible and responsive. That is the name of the game at the end of the day. We all won't be here forever, but we want to make sure our judicial system is. And we, as officers of the court, and part of that judicial system is to make sure that it is a lasting body as it has lasted for the last 250 years. We want to resolve matters and disputes expeditiously without unnecessary expense and through negotiation whenever possible. We teach at ABOTA, one of the first things we want to do in a case is find out how much what are they looking for and how much the other side wants. If it's a case of $37 million, that case is going to probably be disputed for a while. But if it's a case of $37, let's see if we can't resolve that quickly without having those type of cases, blog up and lock up the time of the court. And of course, most cases are between $37 and $37 million. So those are the cases we need to assess how best to resolve expeditiously if they can be. And yet, as proponents of the Seventh Amendment right to trial by jury, not all cases can be resolved. And that is why we have the right to have a jury of our peers decide those cases in a civil matter. To keep our clients well informed and involved in making decisions affecting them, achieve and maintain proficiency in my practice and continue to expand my knowledge of the law. We'll put a pin in that one and come back to that in a second with respect to artificial intelligence. To be respectful of my conduct towards my adversaries, and to honor the spirit and intent as well as the requirements of applicable rules or codes of professional conduct, and encouraging others to do the same thing. In general, I think as trial lawyers or as mediators, these are all aspects of professionalism and our code of professionalism that we can all live by. I want to stop just for a minute there to see if there's any questions so far or any points we need to discuss. I don't really have access. I have access to the chat, but I can't toggle very well. Jeff, you want to help me out with that?
Yeah, I'll be happy to. And I'm not seeing any substantive questions in the chat. I do, a lot of questions are coming to mind, but I'm going to save them until we get a little further into the presentation.
No worries. Then, of course, as ABOTA members, we also have the principles of civility, integrity, and professionalism. And we've written those down in a white paper. And we're happy to share that white paper with anyone. It's on our website at abota.org. But also, if you'll email me at abota@abota.org, I'll be happy to send you that white paper as well. I wanted to go, when you're dealing with professionalism and civility, we as lawyers need to make sure that we act professional and civil, but we can also expect that same behavior from judges as well. And we recently had a webinar at the Aboda Foundation with respect to several different judges talking about the behavior of judges. It's sometimes a top-down issue. You know, the top people at your law firm set the tone for the young associates. The top people in a company in your legal department, they set the tone for the new lawyers there. And the judges in our court set the tone for what's going to be acceptable in their courtroom. We've all read multiple opinions that have come from various courts, especially when they're seeking sanctions. And it looks like at times judges have sided with one side or the other to make fun of the other side. And, you know, that's obviously never appropriate. But there's just a few things I wanted to go over with respect to our principles of civility, integrity, and professionalism. First of all, with respect to the conduct that's expected of the lawyers. We all take an oath that when in court, I will always uphold the dignity of the court and never be disrespectful. That's really important when the other side is you feel like the other side's being disrespectful, or if you feel like the court is being too aggressive or the court is being disrespectful. It doesn't matter. We have an obligation to be respectful of all parties in the courtroom. And sometimes that can be harder than others, but it's a constant reminder that if you try to bring down the conversation in a civil way, it will always end up better than if you take the bait either from the other side or perhaps somebody else in the courtroom that may be having a rough day for one reason or another. Lawyers always should never publicly criticize a judge for his or her rulings or a jury for its verdict. I cannot begin to say how important that is in the last 10 years. I don't think we really saw it so much before 10 years ago, but now we see it quite often. Listen, as a trial lawyer, you don't always win. The best way to handle that is is not through impeachment or criticizing the judge, but it's appealing to the appellate court. Criticisms of a jury that sat there for a week or two, given their time and talent and energy, is never appropriate, even if they don't side with your side. Criticism should always be reserved for the appellate courts. Number 3, I think, is always super important. I learned this as a young lawyer. I was witnessing it happening to another lawyer. We were in Dallas County and a lawyer was running late. That lawyer had been in court somewhere else down the hall, but they had not told this judge. And it was a day that I don't ever want to have repeated for sure with respect to watching any other lawyer, but always be punctual and prepared for all court appearances. And if you're unavoidably delayed, notify the court and counsel as soon as possible. I have yet to ever see a court that once they were notified, they were fine and they could skip to the next hearing. It's just making sure, again, that we have good communication and that's done in a professional and civil way. Never engage in conduct that brings disorder or disruption to the courtroom. Advise clients and witnesses of the proper courtroom conduct expected and required. That is key. We are the advocate for this witness and for this party. To the party, the issues can be raw. To the party, they can really feel like they were wronged or they are wrongfully accused, and it's very emotional to them. It is our job to be not only their advocate in court, but also to make sure their behavior in court is appropriate and good communication with the client and letting them know how things are going to work, what you're going to do, how you're going to take care of them should assuage those fears and anxieties of our clients. Never misrepresent or misquote facts or authorities. And if you find after you have submitted a brief or after you've delivered an argument that anything that you told the court was even slightly off, a letter to that court, to the other side, correcting it immediately is the thing to do. Verify the availability of all clients and witnesses, and if possible, before the dates of the hearing or trials are scheduled, and immediately thereafter, and promptly notify the court and counsel if their attendance cannot be assured. I can tell you through, I feel like I've lived through everything at this point because I've practiced the law for so long. But I can tell you one of the issues where a court did not grant a continuance of a trial is because my opposing counsel had asked for a continuance, saying their expert was not available. Well, the federal judge called to find out where the expert was going to be, and then called that court to find out if their case was going forward. And indeed, that case had settled. The judge did not sanction my opposing counsel, but it was addressing down that no one should. It was a very, very rough day for my opposing counsel. So always just good communication. Find out where your witnesses are going to be. If they have a conflict, make sure they actually know it is a real conflict. Just don't take their word for it. Find out, because your word is your bond with this judge, and your credibility is everything with respect to this judge. Be respectful and courteous to court marshals or bailiffs, clerks, reporters, secretary, and law clerks. A really great federal judge, Alan Albright, just had this lesson of number 8 with his entire class. He sat them down and said, look, the people that work in the courthouse, in the courtroom, they are the people that make your life great. When you walk in that courtroom, it's your house. Go introduce yourself to these people. Make sure that you know what they need. If they need your card, if they want you to stand up or sit down or whatever when you're arguing, make sure you know that, know how to use their equipment. It was a really great lesson coming from a federal judge that didn't have to give that lesson, but it's so important that we remember it's not just the judge that makes our life great. It's everybody that works in the house, that in the courthouse, that makes our trials great. So this is the conduct when we are in court that we should expect with respect to civility, integrity, and professionalism. And likewise, the white paper sets out conduct for judges as well. Be courteous and respectful to lawyers, parties, witnesses, and all court personnel. Control courtroom decorum and proceedings so as to ensure that all litigation is conducted in a civil and efficient manner. And certain judges have a more formal courtroom decorum than others have a less formal courtroom decorum. It's up to us as trial lawyers to know what that court expects, because the court does set the tone. And if we are used to practicing in a court where it doesn't really matter whether the gentlemen wear a tie or not, and then you move over here to a court where you have to wear a tie to get into the courthouse, period, it's in for a little bit of a shock. So as this is a two-way street, the court sets the decorum, and it's our job as lawyers to make sure that we know what it is for all of our clients. Courts should abstain from hostile, demeaning, or humiliating language in written opinions or oral communications with lawyers, parties, or witnesses. They should be punctual in convening all hearings and conferences. And if they're going to be delayed, notify the counsel if possible. The court should be considerate of the time schedules of everyone, lawyers, parties, and witnesses, in setting dates for hearings, meetings, and conferences. And when possible, set a scheduled meeting at the time that does not conflict with the counsel's required appearance before another judge. There is nothing more stressful than being set for multiple hearings in different cities, none of them by Zoom, all in person on the same day. So to the extent that the lawyer knows that we are set on multiple hearings, let the court know, and let the courts be able to work that out. Make all reasonable efforts to promptly decide matters under submission. This is a common complaint of all trial lawyers. Give issues in controversy deliberate, impartial, and studied analysis before rendering a decision. Be considerate of the time constraints and pressures imposed on lawyers by the demands of litigation practice while endeavoring to resolve disputes efficiently. I want to talk about those together if I can. You know, when parties are putting together arguments, and sometimes these arguments take days to put together, as we have witnesses before those hearings, or we have graphics at those hearings to make sure everything comes across in a clear, efficient manner. And then the only thing we get back from the court is granted or denied. It's nice to be able to have the court put together a reasoned thought and opinion so that we can take that to the bank. And here's why. It helps the justice system in general. The trust of the parties to feel like they got a fair shake before this judge or this jury, even if they lost, as long as they know they were heard, they were understood, and there's a reason analysis of why they didn't win this. So these two things, I think, really go hand in hand. Judges should be mindful that a lawyer has a right and duty to represent a case fully, making a complete record and arguing the facts and law vigorously. You know, when I was talking about, sometimes we get these one-word orders that just say this, especially at the end of a hearing. And then a lawyer has the job to make a record, because the losing lawyer sometimes wants to take that up to the appellate level. Sometimes judges can be, taken affront. Good, experienced judges are at the ready and say, this is why you lost. There's 3 reasons. 1, 2, 3. Sometimes they're buttressed by case law. Sometimes they're not. But they've really thought about they know it's a close call. They're making a decision. They're calling balls and strikes, and they're setting it forth for the lawyers then to go do what they want to do. Do you want to take that up to the appellate branch? Do you want to look at the case that I'm relying upon? Do you want to see if you can't resolve this with the other side before moving forward? Judges should never impugn the integrity or professionalism of a lawyer based solely on the clients or the causes he represents. You know, we face this in today's world. We see that in 2025 from the top down in the United States. As trial lawyers, we represent all kinds of clients. Whether you're a civil lawyer or you're a criminal lawyer, sometimes you've got cases and you've got clients that they have a colorable case to prosecute or to defend. And yet someone should never impugn the lawyer because they represent the alleged murderer or the alleged shoplifter or someone that allegedly stole trade secrets or someone that did something else terrible supposedly to your client. Those are things that as a lawyer, we are assigned to represent the client. It is not us who murdered, stole, took trade secrets, or did something else heinous. We are representing the accused in these cases. And yet we do see today, especially from our administrative branch, sometimes the law firm or the lawyers are blamed. I think it's really important that we teach this lesson. Trial lawyers are trial lawyers. We represent all clients, good, bad, or ugly. We want to make sure it is our job to make sure both sides are very well represented so that justice can be done. You know, if you have sometimes we have a pro bono case here on the plaintiff side. I want great representation on the defense side. I want to make sure that if justice prevails for the plaintiff, it wasn't because the defendant had a terrible lawyer or they didn't have a lawyer at all, or they didn't promote the right law. We want them to make sure both sides are well represented so the jury or the judge can make the best call in the system of justice. Requiring court personnel to be respectful and courteous towards lawyers, parties, and witnesses. Again, the judge should require that. But like I said before, what Judge Albright was teaching his class, it's our job to walk in, to meet them, to make sure to make their life easy, not talk too quickly for the court reporter, which is a sin I continue to do, but to make sure they can understand us, slow down. You have your exhibits at the ready. Make sure that you are prepared as a lawyer so that you can be treated respectfully and courteous by the court personnel. The judge should abstain from adopting procedures that needlessly increase litigation time and expense, and promptly bring to counsel's attention uncivil conduct on the part of clients, witnesses, or counsel. I will tell you, in my 30 years of practice, it's over 30 years. I think it's going to be, I can do the math right. I think it's 35 next year. Most great judges will dismiss the jury and then they will call the lawyers up there and say, hey, what is going on over here with your associate or with your party or with your counsel or with that witness? to make sure that that does not continue. We know this goes on in court. We want to make sure that we resolve that as trial lawyers. And it's always great to make sure that a judge that witnesses it sometimes in the courtroom, because sometimes we're in the heat of battle, we don't see what's going on right beside us over here, brings it to our attention so that we can fix those issues. So those are issues, that are addressed in the white paper. There's a lot more as well, with respect to principles of civility, integrity, and professionalism for not only lawyers, but also judges. And then, of course, ABOTA has a foundation that has a program called Civility Matters. And Civility Matters is taught throughout law schools, and various organizations throughout the United States. If you're listening to this program and you've never heard of the program Civility Matters, I'm not going to be insulted. Instead, I would really like for you to reach out at ABOTA, email to abota@abota.org. We will come. ABOTA is in 94 chapters in all 50 states. We will come to you to put on a Civility Matters program. They're anywhere between 30 minutes to 90 minutes. We like to have them in all law schools throughout the United States. We don't like to have lawyers graduate from law school without having sat through a Civility Matters program. And then, of course, we also like to teach civics. And I know that Deb Trupp, our foundation president this year, has made these great hats with Teach Civics now more than ever, because when you're teaching civility and civics and you're teaching that next generation about what they can do to make the world better and their conversations better, that's something that we have an obligation to do as trial lawyers moving forward. Okay, Jeff, that's my next stopping point. Anything there?
Yes, there's so much. Thank you, Jennifer. Very stimulating conversation. So let's start with some advice you might have for younger lawyers, for women lawyers, and most particularly for younger women lawyers, because this topic comes up all the time. What are the appropriate ways to respond when you feel that somebody, an older, more senior lawyer, is being a jerk because they think they can intimidate you, they think they can overwhelm you and scare you? What are appropriate way? What advice do you give to younger and women lawyers on how to respond in those kinds of situations?
So my approach may be slightly different. So I started practicing law in 1989, and I joined a firm of all men. It was a litigation boutique firm in Dallas. They're exceptional lawyers at Figueroa and Davenport. And I was taught by Ernie Figueroa, you really want to make sure, because it's going to happen to everybody, not just young women lawyers, but young lawyers in general. And they'll make comments that somehow the reason these people are doing it is to kind of get you off your mark. They want to make you not sure in exactly what you're going to say. When we walk in the courtroom, we all have our armor on to make sure that we can withstand anything that they're about to say. But especially young women lawyers with people that are trying to intimidate you. I can't imagine this still goes on, but maybe it does in 2025, and calling you things like little lady and sugar and honey. And I was called all that, and I was called that from the bench as well, right? So I think it's always respond in the most civil way, well, Your Honor, or well, Mr. Abrams, and then continue with your conversation. If it gets, in my age now, if someone were to, quote, mistake you for the court reporter, I mean, I would respond to oh, honey, I just absolutely love you. Thank you so much for mistaking me for the court reporter. Can I come over and sit right beside you so that we can get along the rest of this deposition? So, that'll make sure they don't do that again. But I would always make sure you always respond appropriately. If you really think a lawyer is denigrating and incredibly nasty, there's all kinds of ways to address that in today's world. You can stop a deposition, you can make a record, you can submit it to the court. Over here in East Texas, we have a court hotline that if things go on like that, not necessarily just things like that, but anything that's disruptive or disrespectful to the lawyers or the parties or to the deposition itself, you can stop and call the federal magistrate. Now, knowing that there is a hotline that you're supposed to call in the middle of the deposition, really brought that kind of activity and action to a screeching halt when that was, and it's printed in the Eastern District local rules with the phone number that you're supposed to call. And it was to stop behavior like that. So I think that's up to the court, but it's also up to us as young lawyers. And if you don't have a mentor at your firm or your company that you can go to, call someone at another law firm and say, hey, I would really like to be able to have lunch with you to find out how you handle this situation, because I've got a difficult situation that I'm dealing with. I know that when I was a young lawyer, one of my senior partners called another female, because there weren't any at my firm at the time, Barbara Lynn, who went on to be a federal judge. That's how I met her, ended up having cases with her. She was truly a delight. I think she retired off the bench a little bit earlier this year. But she could always respond with the most civil way, and letting them know, I know what I'm doing. I'm prepared for this. And here's how we're going to handle this situation. And then at another sort of psychological level, the only reason they're doing this to you is to get you off your mark. So when you see it coming, don't be offended. Think, oh, yeah, this is what I heard about. I can't believe you're that kind of person. Okay. And you can think that in your head while you're responding civilly. And you can always know this person tried to pull that on me and it just didn't work. We've always had civil problems for a long time, Jeff. The ABA Journal came out with it about 20 years ago now. We've had articles written in every publication you can imagine about the incivility of lawyers in their cases. But I think we would come back to always remembering this is a profession that we're dealing with to keep ourselves civil. There's one other thing I want to go through real quick on what is civil and then uncivil. So, we have this issue about what a zealous advocate is. And we're supposed to be zealous advocates with the noun. And yet, when you look up with the noun definition, sometimes that's fanatical, right? Uncompromising in pursuits. That is not who we are supposed to be. But that is not what our oath is either, is to be a zealous advocate. We are supposed to zealously advocate for our clients in the adjective sense, which means fervent, ardent, passionate, devout, devoted, enthusiastic. Make those arguments, but don't be so entrenched that you are a zealot, never to be moved. There's a difference between between zealously advocating and being a zealous advocate.
So let's talk more about that.
Yeah.
Because as lawyers, we are under obligations to zealous advocacy, duties of undivided loyalty, efforts to get the best possible result for our clients under the circumstances. And Jennifer, when you're sitting there and maybe there's a young lawyer on the other side taking a deposition, and don't you ever think to yourself, boy, maybe I could, through how I object or whatever, how I behave in this deposition, I could knock this young lawyer off his or her mark. The deposition won't go as well. It really will benefit my client. We get a better result. How do you balance in your own mind, in your own practice, the uh, the obligation to get your client the best results under the circumstances and these concepts of civility where you think if you kind of turn up the temperature a little, your client might do better in the case?
So surely our client could do better in the case because we are the lawyers that should be the most civil in the courtroom. We are the lawyers that are the most respectful. I will tell you that there is not a juror that sat through a jury trial that likes the lawyer that is being disruptive or that thinks they're in LA law, or I'm really dating myself there, Law and Order, let's put it that way, and decides they're going to cuss at the judge and not be held in contempt or something absolutely crazy like that. Um, if we can't win under the law, our job is to zealously advocate their position and for them. It is not to win at all costs, including cheating or making up evidence or
No,
lying.
excuse me, I'm not talking about that. The
Yeah,
way I've conventionally heard it described is zealous advocacy within the bounds of law. And
absolutely.
there's no law saying, well, I can't, you know, try to knock this guy or this woman off his mark a little bit. So let's say you're in a deposition and you think that a young lawyer is insecure, and that if you are more aggressive or more assertive in your objections in your defense of the witness, that the young lawyer will get frustrated and won't do as good a job. How do you balance that?
Well, then we're not that good of a lawyer if that's how we're going to act. And if you'll remember, I guess it was just maybe 15 years ago, with products cases or with personal injury cases, we used to take depositions and then all go to lunch together at the break and then
Yeah.
come back and tee it up again. The fight is not with the other lawyer. And you want the other lawyer to be a great lawyer, to go on to be the civil professional lawyer that they can be. Knocking them off their mark brings you down as a person. I mean, it's part of our inner why, our inner being as to who we are and why we are going to insist on integrity and professionalism. And even with that, Jeff, sometimes you're going to have people talk behind your back and say, oh, yeah, well, umpteen hundred years ago, that lawyer did so and so. I mean, there's always going to be someone that's going to say something rough about somebody that maybe that they're jealous of or they didn't understand something. So as long as you know that you've always acted with the utmost integrity and professionalism, that's what matters. I will say there's going to be times like we read through those things, and there's definitely times where you think that because your client usually has told you X, or you have a case that says Y and you're arguing that in court, and then you get back to the office and you find out, hey, wait a minute, that's not exactly right. The professional thing to do is pick up the phone, call the other side, call the judge together, and tell the judge. Absolutely. Every time. Number one, the other side's going to respect you for who you are. Number two, the judge is going to respect it because they will find out what the case says or what the true facts are from your client. And you want to be the one telling them that. You want to set the record straight always. So, um,
Yes, I'm reminded of a civility lecture I heard early in my career from a truly great lawyer, since passed away, named Ellis Horvitz here in Los Angeles. He was the dean of the appellate bar, very distinguished man, and he was speaking to a group of young lawyers, and he went up to the podium, and the first words out of his mouth were, "Over the many years, many of our most crushing defeats have come at the hands of perfect ladies and gentlemen." And I think that about sums it up. Let's switch to a little different topic, which is
yeah.
over since you started practicing law. Certainly, I've started practicing law. Standards of how people dress have changed. There's less formality in society in general, practice of law in many cases. So, what do you tell younger lawyers, particularly women lawyers, about how to dress when going to depositions, client meetings, court hearings? I have heard conversations uh, among women lawyers about the significance and symbolism of everything from pantsuits to open-toed shoes to hairstyles and all sorts of other things. What standards do you enforce in your own firm, and what advice do you have to young lawyers, men and women?
Well, if you're talking about being in the courtroom, I can so tell you're from California and not from Texas. So over here, we're very formal in the courthouse and very formal in the courtroom. And in federal court, you're not coming in unless gentlemen have on a tie and coat. And if you didn't bring a tie and coat, that's fine. They have clip-on ties and jackets that somebody else wore that you're not going to want to put on. So a lot of my clients work for computer companies and tech companies, and they're out there in California. So we do have them attend we've been doing depositions every day this week and every day last week. We always cover this issue about what to wear. Because if you're a programmer, I mean, you're not used to wearing courtroom attire for federal court somewhere in Texas. So we do tell them coat and tie always. We want to make sure, because you're going to be talking to the shopkeeper, the farmer, the rancher, the school administrator. It's going to be sitting there listening to you in court. And when your deposition is played, and they had to put on a tie that day, they don't wear one either. So you need to make sure and respect what they wear. And, I thought this for as long as I've been practicing law, and I guess it was taught to me by Ernie Figueri and by my dad, who was also a great trial lawyer. I always think you dress a tad bit a cut above, especially the younger that you are. If you come in on Saturday and you wear the closest thing to your bed that was clean, and it just happens to be super grungy, and that partner sees you in that, that is something that's just driven into their brain. So I would always think that you would wear something that's a little bit more professional. Is whether you wear a dress or a skirt or pants as a female. I think most women know what looks good on them. I don't think pants are my friend, so you'll almost always see me in skirts or dresses. That's just, who I am. When I first started practicing law, and I moved back to East Texas for the Texas tobacco litigation, um, there were two local judges over here in Bowie County that said that women had to wear dresses and skirts in the courtroom to pick a jury. So it wasn't worth arguing for me. Just wore it. Totally great. Never had a problem with it. So it was all fine. I don't do that now for that reason. I just happen to like dresses and skirts better. But I don't think that it matters for men or for women, as long as you're dressed appropriately for court. I would always make sure that you are dressed just that cut above. I've heard lectures from in diverse bars where they say that the minority bar always has to dress up. And I thought that was really interesting, because I always thought that about the female bar had to dress up. But in general, everybody, if you respect the decorum of the court, you should dress up. Our office dress is business casual every day. People do know if clients are going to be here. Are we going to have meetings with other lawyers? Are we going to have any type of depositions here? And if so, those days are not business casual. But in general, we're more of a business casual world. But just because your dress is business casual doesn't mean your attitude has to be more lax or casual to the point it becomes disrespectful.
So there are many questions in the chat about
Okay.
how this transports over to the world of mediation. And
Yes.
as mediators, we're supposed to be neutral. We're hired by everybody. We have some loyalty to both sides, and we get paid by and large by both sides. And yet at the same time, we sometimes see some bad behavior in mediations. What are your expectations, and what do you think is the proper role of the mediator when somebody gets a little out of line?
Well, different the subject matters, and for mediators, and I know that y'all all mediate a variety of subjects. We do expect, obviously, the mediator's job is to resolve the case. It is not to teach either side what the law is for their case, or decide with one case, or decide, oh, wow, plaintiff's got a great case, defendant should pay, or, defendant has a really great case, the plaintiff should go away. It's to draw both parties together. I think the mediators decide, we have a issue over here with some of our more hot litigation, whether it's appropriate to have a joint session at the beginning or not. For years, when we did cases that the plaintiff needed to have, I'm not going to say necessarily a vent, but the plaintiff needed to be able to say to someone what happened to them, why they were hurt, and how they wanted to resolve it, to be able to express that to the other side. And usually you had an insurance adjuster or the other party with the insurance adjuster there. I think that can be really, really helpful. If you have two parties that are corporates parties, that it doesn't really matter. They fully understand what the other side is, and the discussions are not going to go well if they get in the room together. Sometimes it's better to start separate, and then you can have just the lawyers come together, or the mediator can have just the parties come together, especially if neither party is a lawyer. Good lawyers always want to say, hey, listen, this is your only opportunity in this mediation or this attempt to resolve this case where you can do a deal with the other side. Because we're going to go into court and one side wins and one side loses. It's not going to be something where at the end of the day you can say, hey, can we not do that? Instead, we go do so and so because the other side's already got their verdict. So this is your opportunity to see, can we do a business deal to work this out together? And sometimes that needs some time at the beginning of the deposition in separate rooms before the parties can say, hey, listen, if I could just talk to the other side real quick, I think we might be able to do a deal. I think we might be able to get that resolved. And I think that's really helpful when you've got business people that want to do a deal on both sides. It's just a different, I'm sure all the mediators here are super experienced. I know that those two different type of cases, but it's also your job as the mediator, if a lawyer gets out of line, to remind the lawyer, listen, our job here is to try to resolve this. Our job here is not to hate the other party or the other lawyer, for sure. There's all kinds of old adages that we know in our head that we just forget at the heat of the moment. Like the one lawyer in town is super poor, but both lawyers in town, they're able to make a living. Because if you're the only show in town, you got to have the other side well represented if you're going to be able to make a living doing this wonderful profession that we belong to. So hope
Yes, I
that's helpful.
sometimes have to remind lawyers who engage in that kind of conduct that you're really not here to prove a point. You're here to make a deal. And if you want to
Yeah,
prove a point, there's a perfectly good courthouse right over there. Give it your best shot. As long as you're here, we're trying to make a deal. We have
that's
just
right.
a minute left. Mauricio Gom Santos had a general comment and would like to express it out loud. We have just a minute, Mauricio, but please unmute yourself and make your point.
Thank you. Thank you so much. Good morning, everyone.
Good morning.
I am a Brazilian citizen and a US citizen. I am a Brazilian lawyer, New York lawyer, and live in Miami. My practice has been in the international arbitration field, occasionally as mediator, but basically as arbitrator. The topic of today's webinar was so interesting because it says civility, integrity, and professionalism. In the international setting, this is something that we have to understand cultural differences. And sometimes, for example, in a mediation, if you arrive 2 minutes later, that may be very disrespectful, depending on what the other side sees in terms of timing. If you shake hands with someone, depending on the way you shake hands and you touch the body, touch the shoulder of someone, this can be outrageous. But in some areas, some geographical areas, this is a sign of being nice. And what I see in international arbitration as an arbitrator, especially with American lawyers, when they do cross-examination, sometimes they are very aggressive. And the role of the arbitrator is to sort of to balance these cultural differences so that everybody is in a comfort zone. That's my 2 cent comment. I don't want it to go further. Thank you.
Okay, thank you. And with that, our time is up. So Jennifer Doan, president of Aboda, thank you very much. It was a fascinating presentation. I think everybody got a lot out of it. Those who are in a position to support the Harvest Regional Food Bank, please do. We welcome your contributions or contribution to a food bank in your own area or one that is important to you. If you let us know about your contribution, we will be delighted to add it into our running total. Jennifer Doan, thank you again so much for a wonderful presentation. And with that, we are complete.
Thank you, Jeff. Everybody have a blessed day. Thank you very much.
Thank you.